Hi guys, it's me again, Attorney Al Jumrani, and welcome back to the House of Law. So, kamusta na kayo dyan mga House of Law? Nakapag-beauty rest na ba? Fresh na ulit mula sa excessive, exorbitant at unconscionable na exam? So, I hope na panood nyo yung aking first video on Civil Law Exam Part 1 Suggested Answers. Sinabi natin pag mahina ang loob nyo, skip nyo muna yon. Pero hindi, panoorin nyo muna yon bago nyo panoorin ito. I'm sure naman kaya-kaya nyo itong dalawang exam na ito. So anyway, let's get on with it! Ayan, so before I proceed, please don't forget to like this video. Please don't forget to subscribe kung hindi ka pa nakakapag-subscribe. And please click that notification bell para ma-alert ka pag meron akong bagong video. So ayan, so let's do this. So question number 1. This item has two questions. Pepe and Pilar are adjoining lot owners. Suppose Pepe's lot is titled and without his knowledge. It was encroached upon by Pilar, whose lot is untitled, but who honestly believed that the encroached portion where she built a small bungalow house is still within her property. First question, is Pilar a builder in good faith? Discuss Pepe's right as against Pilar. Explain briefly. Letter B, suppose it is Pilar's lot that is titled and Pepe's lot is untitled. Would Pilar be a builder in good faith? Discuss Pepe's right as against Pilar. Explain briefly. So here is my suggested answer. Simulan natin sa letter A. No, Pilar is not in good faith. Under the Civil Code, a builder is not in good faith if he or she is aware or ought to be aware that the property belongs to another. When land is registered, registration is constructive notice to the whole world. Moreover, when something is built on land belonging to another, the builder loses everything and is only entitled to the payment of necessary expenses for preservation of the land. In this case, Pepe's land is registered land. Pilar is constructively notified thereof. Thus, Pilar is a builder in bad faith. Pepe can demand Pilar to vacate the land and demolish Pilar's bungalow house with due reimbursement of the necessary expenses. O ngayon, for letter B, yes, Pilar would be a builder in good faith. Under the Civil Code, a builder is deemed in good faith if he or she is not aware that the property belongs to another. There is also no constructive notice if the land is not registered. The landowner on whose land something has been built, planted, or sown may appropriate the thing after indemnifying the builder, planter, or sower of his necessary, useful, and ornamental expenses. He or she may also sell the land unless the land is of greater value than what has been built, planted, or sown, in which case the latter may pay rent. In this case, Pilar is a builder in good faith because she honestly believed that the encroached portion is within her property. She is not also expected to know that the land belongs to Pepe because Pepe's ownership has not been registered. That said, Pepe may choose either to appropriate Pilar's bungalow house after payment of indemnity or to require Pilar to pay rent. Ayan. For question number 2, ito ang topic nito, nahulaan na ng mahiwagang fishbowl. Pero iba lang yung sitwasyon. So let's see. This item has two questions. Thea, Vanessa, and Sofia are siblings who are co-owners of a 600 square meter parcel of land covered by TCT number 12345 situated along Bangkal Road, Makati City. Thea decided to sell her share, an undivided 200 square meter portion of the property, to Alisa, a Filipino nurse who has been living in Canada for the last 10 years. Alisa, without the knowledge of Sofia and Vanessa, built a modest house on the 200 square meter portion abutting the road and leased it to Stel for 15,000 per month. Question letter A. Could Thea legally transfer her share of the property to Alisa without the consent of Vanessa and Sofia? Explain briefly. Letter B. Can Vanessa and Sofia respectively legally demand from Alisa a 1/3 share in the rentals? Explain briefly. Alright, so here are my suggested answers. Let's start with letter A. Yes, Thea could legally transfer her share to Alisa without the consent of Vanessa and Sofia. Under the Civil Code, a co-owner shall have the full ownership of his or her undivided share in the co-owned property, and may sell or alienate the same without the prior consent of the other co-owners. The buyer acquires the said share and substitutes the former in the co-ownership if no partition is made. In this case, Thea was the co-owner of 1/3 of the 600 square meter property or 200 square meters thereof. Consistently, Thea's buyer, Alisa, only acquired a 200 square meter portion of the co-owned property which pertained to Thea. Thus, Thea's sale to Alisa is valid even without the consent of Vanessa and Sofia. Alright, letter B. Yes, Vanessa and Sofia can demand their respective 1/3 share in the rentals. Under the Civil Code, the co-owners shall share in the benefits as well as in the charges proportional to their respective interests. Income from rents is a benefit that the co-owners have the right to share. In this case, Alisa became a co-owner after buying Thea's share. Although Alisa did not get the consent of Vanessa and Sofia before constructing a house and leasing it to Stel, she is bound to hold in trust and deliver upon demand the shares of Vanessa and Sofia in the rental income. Thus, Alisa should give to Vanessa and Sofia their respective 1/3 share in the rentals. Okay, so let's check question number 3. This item has 2 questions. With the intent to develop a subdivision, Oliver bought a parcel of land adjacent to a subdivision owned by Phil. Oliver's land had no direct access to the highway as it was blocked by a camote plantation owned by Josh. Phil's subdivision, on the other hand, already had a direct access to the highway. To facilitate the release of the license from the Department of Human Settlements and Urban Development, Oliver presented a contract to sell between him and Josh over the camote plantation on the representation that he would construct an access road thereon. Pending approval of the license, Oliver sought the consent of Phil to connect the road that would be built by him with the main road of Phil's subdivision. Phil allowed him to do this pending their negotiation on the compensation to be paid. With the eventual grant of the license, Oliver began the development of his subdivision. To protect the right of way over Phil's subdivision, Oliver was able to cause an annotation of adverse claim on Phil's property. However, when Oliver's subdivision was already completed and with the adverse claim annotated, Oliver believed that he no longer needed to buy the camote plantation and accordingly rescinded the contract to sell with Josh. When Oliver and Phil failed to arrive at an agreement on the consideration for the easement, Phil built a wall blocking the road constructed by Oliver that connected Oliver's subdivision with his. Oliver filed a complaint seeking the establishment of an easement of right-of-way through Phil's subdivision, which Oliver claimed to be the most adequate and convenient access to the highway. On the other hand, Phil filed a petition to have the adverse claim cancelled. Ang haba ng facts. Okay, anyway, ito yung dalawang questions. A. Is Oliver entitled to a right-of-way through Phil's subdivision? Explain briefly. And letter B, is there a basis to have the adverse claim cancelled? Explain briefly. Okay, so here are my suggested answers. Letter A, no, Oliver is not entitled to a right-of-way through Phil's subdivision. Under the Civil Code, to be entitled to a right-of-way, the dominant estate must be surrounded by other immovables without any access to a public road. The isolation must not be due to the proprietor's own acts. In this case, Oliver's property was surrounded by the properties of Josh and Phil. At the start, in order to obtain a license to develop his subdivision, Oliver had entered into a contract to sell to buy Josh's property to construct an access road thereon. But when the license had been granted, Oliver canceled his contract to sell with Josh. Consequently, however, Phil had closed the temporary access road that he granted to Oliver due to the failure of negotiation on the compensation. Oliver's predicament is his own making. Thus, Oliver is not entitled to a compulsory right-of-way. He should either negotiate to buy Josh's or Phil's property. Ayan. Letter B. Yes, there is a basis to cancel the adverse claim. Under the law, an adverse claim is a notice that the claimant has a right adverse to the registered owner. The annotation is to give notice to third persons and protect the claimant's rights during the pendency of the controversy. In this case, Oliver filed the adverse claim to protect his right to have access while he was negotiating with Phil the compensation for the right of way. It was contingent upon a final agreement on the right of way. Considering, however, that the negotiations failed and Phil was no longer willing to give Oliver a right of way, the adverse claim had lost its purpose. Hence, the adverse claim may now be cancelled. Ayan. Now, let's go to question number 4. Now, the topic in this question was, nahulaan, no? Pero, again, iba din ang facts. Ayan. So, the question: the spouses Santos are the registered owners of Lot 2 located in Umaga Subdivision, Caramoan, Camarines Sur, covered by TCT number 1369. Lot 2, which has been occupied by the spouses Santos for about 11 years, has a one-story residential house which was already erected thereon when Lot 2 was purchased by them from the spouses Cruz in 2005. At the time of the acquisition of Lot 2, the adjoining lot, Lot 1, which was also owned by the spouses Cruz, was an idle land without any improvements. Lot 1 remained empty until the spouses Cruz started the construction of a two-story residential house thereon in 2018. The house constructed on Lot 1 being taller than the spouses Santos' one-story residential house, the spouses Cruz's two-story residential house obstructed the light, air, and view of the spouses Santos' residential house. The spouses Santos bemoaned how prior to the construction on Lot 1, they received enough bright and natural light from their windows. The construction rendered their house dark such that they are unable to do their normal activities in their house without switching on their lights. Ayan, easement of light and view. Okay, so here is my suggested answer. The question is, have the spouses acquired an easement of light and view with respect to Lot 1 owned by the spouses Cruz? Explain briefly. My answer is yes, the spouses Santos acquired an easement of light and view. Under the Civil Code, easements may be acquired by prescription or by title. It is acquired by title when there exists an apparent sign of easement between two estates established or maintained by the owner of both, should either of them be alienated. In this case, both lots 1 and 2 were owned by spouses Cruz. On Lot 2 existed a one-story residential house with windows. Lot 1, on the other hand, was an idle land with nothing constructed thereon. The house with its windows on Lot 2 was an apparent sign of easement of light and view. It therefore forbade spouses Cruz from constructing anything that would violate the easement. Hence, spouses Cruz cannot deprive the spouses Santos of their light and view. They could only construct a building on Lot 1 after observing the distances allowed by law. Ayan. So ito, masaya nating binabalita na question number 5 ay nahulaan ng ating mahiwagang fishbowl. Alright, so the question is, in 2014, a wealthy young couple, the spouses Tan, moved by the spirit of generosity and love for their hometown in Siquijor, decided to donate a 1-hectare lot in favor of the province of Siquijor. The deed of donation pertinently provides, the herein donors hereby voluntarily and freely give, transfer, and convey by way of unconditional donation unto said donee all of the rights, title, and interest which the aforesaid donors have or which pertain to them and which they own exclusively in the above described real property over a 1-hectare portion of the same, solely for hospital site only and for no other purpose, where a provincial government hospital shall be constructed. The donation was recorded in the Registry of Deeds, and a certificate of title to the property was transferred to the province of Siquijor. In accordance with the deed of donation, the construction of a hospital building was started in the following year. However, for reasons unknown, only the foundation of the hospital building has, to this day, been completed. Question: do the spouses Tan have valid grounds to revoke the donation? Explain briefly. Okay, so my suggested answer is no, the spouses Tan have no valid grounds to revoke the donation. Under the Civil Code, a donation is an act of liberality which transfers a property to another who accepts it. Donations may be conditional or unconditional. In case of conditional donations, the law on obligations and contracts shall apply. In this case, the donation is a conditional one, even though it states unconditional, because the donee, the province of Siquijor, was obliged to construct a hospital. The deed of donation, however, did not provide for a period for its completion. Here, the province had already started with the construction, although only the foundation has been finished. Thus, the deed of donation cannot be revoked. Okay, question number 6. Being an overseas worker, Salvador issued to Ronaldo a duly notarized special power of attorney or SPA authorizing the latter to enter into a contract of lease over Salvador's property covered by TCT number 122433 for a period of 3 years with SISI Corporation. Salvador entrusted to Ronaldo the owner's duplicate of the TCT in case SISI Corporation needed to verify the same. Hearing rumors that the subject property was sold, Salvador went to the Register of Deeds and was shocked to find out that TCT number 122433 had been cancelled and TCT number 334388 had been issued in Eduardo's name. To vindicate his property rights, Salvador filed a complaint for cancellation of title and reconveyance. Salvador was able to prove that he was out of the country when the purported sale was executed. On the other hand, Eduardo claims to be an innocent purchaser for value, stating that he paid the fair market value to Ronaldo and that he relied on the fact that Ronaldo presented the original owner's duplicate of Salvador's TCT. He likewise inspected the property and determined that Salvador was indeed the owner. If you were the judge, decide, explain briefly. Ayan. So here is my suggested answer. If I were the judge, I would decide in favor of Salvador. Under the Civil Code, an agent may only exercise the powers expressly authorized or those incidental thereto. Acts entered by the agent without authority or in excess of his or her authority shall be unenforceable against the principal. Furthermore, a third person dealing with a purported agent must require the presentation of the power of attorney or the instructions as regards the agency. A buyer who does not examine the authority of the agent is not an innocent purchaser for value. In this case, Ronaldo was authorized only to lease Salvador's property as shown in the special power of attorney. Had Eduardo exercised due diligence by requiring Ronaldo's authority, he would have known that Salvador did not authorize Ronaldo to sell the property. Thus, Salvador's complaint for cancellation of title and reconveyance should prosper. Okay, number 7. Atoy is one of the 5 children of Jawo. Jawo was the registered owner of a 4-hectare parcel of land in Santa Cruz, Laguna, covered by TCT number 77347. When Jawo died, the owner's duplicate of the TCT was kept by Jawo's daughter, Akiko, sister of Atoy, who resided in the said property. Wanting to have the said 4-hectare property registered under his name, Atoy got in touch with France, who had special connections with the Register of Deeds of Santa Cruz, Laguna. TCT number 77347 was then cancelled and TCT number 84660 was issued in Atoy's name on January 29, 2013. Atoy immediately mortgaged the property to the Rural Bank of Santa Cruz or RBSC. Upon default and after being declared the winning bidder in the extrajudicial foreclosure, RBSC consolidated ownership with the issuance of TCT number 94477 in its name. Question: how will Akiko and the other heirs of Jawo be able to successfully argue that RBSC is not an innocent purchaser for value? Explain briefly. Okay, so here is my suggested answer. According to law and jurisprudence, an innocent purchaser for value is one who has no notice, either actually or constructively, of any defect in his or her title or in that of his or her transferor. Furthermore, when there are circumstances that should impel one to conduct an inquiry, a reliance on the title is not sufficient. In this case, Akiko and the other heirs of Jawo can argue that while the title was in the name of Atoy, the property was occupied by Akiko. If RBSC had conducted an ocular inspection, it would have known that the seller was not in possession. Moreover, had RBSC inquired with Akiko why she was in the property, RBSC would have known that the property was inherited land that had not yet been settled and distributed among the heirs. Lastly, as a bank, RBSC was mandated to exercise extraordinary diligence in its dealings, especially in the purchase of real properties. Ayan. Diba? So, dahil ang tanong ay how, ayan, so lahat na ng mga pwede nyo i-argue, ilagay nyo na sa sagot nyo. At hopefully, yung mga yun ang lumabas din, or ang naisulat ninyo sa sagot ninyo. Alright. So, question number 8. How does the new civil code distinguish between immovable and movable properties? Explain briefly and give 2 examples for each. Alright, so my suggested answer is very simple. According to the civil code, immovable properties are those that are immovable by nature, by destination, by incorporation, and by analogy. Examples are lands and buildings. On the other hand, movables are those excluded from the enumeration of immovable properties and those which can be moved from place to place. Examples are books and cars. Ayan. Okay, we're almost there. Question number 9. This item has 2 questions. This case involves 2 competing titles. TCT number 23456 in the name of Flor and TCT number 65432 in the name of De Luna. Flor's title was derived from Rodrigo. Rodrigo's title was originally obtained through a judicial confirmation of title in 1950 based on a survey plan approved in 1931. On the other hand, De Luna derived her TCT number 65432 from Diaz, who obtained an original title through judicial confirmation of title at a much later date in 1970 on the basis of a survey plan approved in 1921. It turned out that Flor's TCT number 23456, although titled prior in time, was based on a survey plan that was marred with numerous blatant, obvious, and serious defects, to the point that the trial court found it dubious, irregularly approved, and was therefore fake. Okay, so there are 2 questions. First question, discuss the principle of qui prior est tempore, posture est jure in the torrent system of land registration. Letter B, as between Flor and De Luna, whose title should be declared valid and whose title should be voided? Explain briefly. Alright, so here are my suggested answers. Letter A, the principle of qui prior est tempore, posture est jure simply means that the one who is first in time is first in right. Applied in the torrent system of land registration, the one who has earlier registered his or her title has a superior right over one who has registered his or hers later in time. Okay, for letter B, as between, my suggested answer is between Flor and De Luna, Flor's title should be declared valid. Applying the principle of qui prior est tempore, posture est jure, one who is first in time is first in right. In this case, Flor's title was derived from the title of Rodrigo, which was registered in 1950, while the title of De Luna's title was derived from the title of Diaz, which was registered in 1970. That the survey plan upon which Rodrigo's or Flor's title is based was allegedly irregularly issued cannot affect his or Flor's title. It is the title that prevails, not the survey plan. A certificate of title is indefeasible, incontrovertible, and conclusive unless cancelled or annulled in an appropriate direct proceeding. Ayan. Kung hindi kayo agree dun ha, alam ko, nafe-feel ko na hindi. Paki-comment lang down below. Okay, so let's go to question number 10. The question is, in 2008, a fire razed the Register of Deeds of San Fernando, Pampanga Register of Deeds. Several titles on file were burned. Long before the fire, Tito, Vic, and Joey had been living in a 350 square meter lot covered by TCT number 49933, which they inherited from their parents. The original of TCT number 49933 on file with the RD was among the titles which were burned. To effect the partition agreed among them, the siblings filed a verified petition for reconstitution of the TCT before your court. To support the petition, the siblings presented first a notarized affidavit of loss, duly recorded and registered with the RD, a photocopy of TCT number 49933, real property tax declarations and receipts to evidence payment of real property taxes, together with a sketch plan and subdivision plan, a Land Registration Authority report which states that the survey and subdivision plans and the technical description of the property may be used as a basis for inscription of the technical description of the reconstituted property, microfilm copy of the plans and technical description on file with LRA, and the extrajudicial settlement of estate executed among them. The public prosecutor, duly deputized by the Office of the Solicitor General, prays for the denial of the petition and argues that the foregoing documents are insufficient for reconstitution of TCT number 49933. Question, should the petition for reconstitution be granted? Explain briefly. Wala na bang mas general pa sa tanong na to? Okay, anyway, so here's my suggested answer. No, the petition for reconstitution should not be granted. Under the law, when the original copy of a transfer certificate of title is lost or destroyed, it may be reconstituted using primarily the owner's duplicate of the transfer certificate of title or a certified true copy of the certificate of title previously issued by the Register of Deeds. In this case, the original of TCT number 49933 on file with the Register of Deeds was destroyed when the Register of Deeds of San Fernando was burned. Tito, Vic, and Joey should have presented their owner's duplicate of TCT number 49933 or a certified true copy thereof. However, what they presented were a photocopy only and an affidavit of loss of said title. The other evidence presented, like the real property tax declaration, survey plan, and microfilm of technical description, could only establish the identity of the land but not to prove the issuance of the original of TCT number 49933. Thus, the petition for reconstitution should be denied. O yan. Pag nag-apply ba ako sa Register of Deeds, pwede na ba ako? Okay. Next question. Question number 11. Ayan na naman tayo. Nahulaan po ito ng mahiwagang fishbowl. So, question is, Ellie borrows 2 million pesos from Mia and mortgages a parcel of land to secure the loan. The mortgage provides for a 5% monthly interest, a 5-year maturity period, a default provision in case of non-payment of interest or principal, and an extrajudicial foreclosure provision. On the 4th year, Ellie fails to pay interest for 3 consecutive months. After sending a demand letter, Mia declares Ellie in default and extrajudicially forecloses the property. Mia is the highest bidder in the foreclosure sale and consolidates ownership upon the lapse of the redemption period. Question, can Ellie have the foreclosure annulled and recover the property? Explain briefly. Ayan, andito na naman tayo sa excessive, exorbitant, at unconscionable. Tingnan natin paano ngayon papasok dun sa ating suggested answer. Okay, here goes my answer. Yes, Ellie can have the foreclosure annulled and he can recover the property. According to jurisprudence, excessive, exorbitant, and unconscionable interest is void and cannot be imposed. Particularly, the rate of interest at 5% per month has been held to be too high as it would make the annual interest at 60%. If the interest rate is void, then the principal obligation is not yet due and demandable, applying the rule on application of payments that the payment shall be applied first on the interest and then on the principal. The interest should first be computed at the legal rate and then paid. In this case, Ellie contracted to borrow 2 million from Mia with an interest of 5% per month. This rate is void and cannot be collected. The legal interest rate of 6% per annum should be imposed instead. This being the case, Ellie's obligation is not yet due as it would require a recomputation of the amounts due. First, the proper interest, then the principal. Thus, it was premature for Mia to foreclose the mortgage property. All proceedings pursuant thereto should be annulled. Ayan. Okay, question number 12. Okay, so for question number 12, ayan, legal forms, no? So, dun sa syllabus, you were hinted, no, na baka 4, no? In fact, 4 talaga nakalagay dun. Pero ang pinagawa sa inyo ay itong deed of contract to sell. Okay, so the facts are, Luz is the owner of a parcel of land consisting of 500 square meters located in San Miguel, Bulacan and covered by TCT number R-248016. Luz agreed to sell to Minda the land for 500,000 pesos payable in 10 monthly installments, with the first installment payable upon execution of the contract to sell, to which Minda acceded. They also agreed that the title to the land shall only transfer to Minda upon full payment of the consideration, and that any and all taxes, fees, and expenses incidental to the sale shall be paid by Minda. Draft a notarized contract to sell between Luz and Minda. Okay, so lahat ng instructions nandun, lahat ng mga stipulations din, andito na rin sa problem. So ngayon, hindi ko alam kung paano yung format ninyo, pero this is how I would write it or prepare it, no, with of course very little time. Kumbaga, kung bigyan mo ako ng papel ngayon with a ball pen, ganito itsura ng aking draft contract to sell. Alright, so let's see it. So, syempre sa ibabaw, deed of contract to sell, and then first line, this contract entered into by and between. Okay, the party is Luz, herein after the seller, and Minda, herein after the buyer. Okay, and then state the parties herein agree that. Okay, ina-number ko yung mga stipulations na nandito sa problem. So, question number 1, stipulation number 1, for and in consideration of the price of 500,000 pesos payable in 10 monthly installments, with the first monthly installment payable upon execution of this contract, the seller shall sell to the buyer that parcel of land consisting of 500 square meters located in San Miguel, Bulacan, and covered by TCT number R-248016. Stipulation number 2, title to the land shall only transfer to the buyer upon full payment of the consideration. And stipulation number 3, all taxes, fees, and expenses incidental to the sale shall be paid by the buyer. And then, put the date and the place of execution of the contract. Done this November 16, 2022 in Manila, Philippines. And then, the parties should sign. So, SGD or signed Luz, the seller, and SGD or signed Minda, the buyer. Now, because the instruction required a notarized contract, so dapat lagyan nyo ng acknowledgement. So, this is my simple acknowledgement, again, without following a template. So, Republic of the Philippines, Manila, SS. And then, before me, personally appeared Luz with SSS ID number 1234 and Minda with SSS ID number 5678, their identification cards bearing their photographs and signatures. They acknowledged to me that they executed the foregoing contract to sell and that the same is their free and voluntary act. That's it. Witness my hand and seal this November 16, 2022 in Manila, Philippines. Okay, signed, Notary Public. Ayan. Kung lalagyan nyo ng pangalan to, I would think, a generic name would be safe, no? Like Juan de la Cruz. Okay, and then of course, sa dulo or sa left side, no? Lalagyan nyo yung document number, page number, book number, and then of course, series of 2022. Ayan. So, finally, natapos din, no? So, that is Civil Law Part 2. Okay, so I know na first time, no, na sa isang araw, both morning and the afternoon exam ay same subject, civil law. Pero sinabi naman na natin yan, no, na this subject is quite close to the heart, of course, of the chairman. Ito ang talagang forte niya, ito ang kanyang kinalakihan, kumbaga, with his father being a civil law expert as well. And siguro in the past din, there was this sentiment na sobrang dami ng topics in civil law na hindi rin nabigyan ng attention. Okay, kaya eto na yon. Pero this may be the first and maybe last for a long time, no? So, kasi yung next year kasi, balik na ulit doon sa dati na isang half day lang civil law, which is morning ulit. So, at any rate, naging masaya, exciting, and challenging itong journey na to with you guys. And I am very thankful for all your support. Sa lahat ng mga nanood ng videos ko, hindi lang yung mga videos ko this year, but also the videos that I prepared and posted since 2020. Ayan, pinanood nyo talaga. Maraming salamat, no? I am very grateful, I am very privileged, no, to be part of your journey to become a lawyer. Laging tatandaan talaga, no, na walang imposible pagka may pangarap, Walang imposible pag pinaghirapan nyo. And I sense that you really want this. And so from day one, since I created this channel, I said I want to help students. I want to help produce more lawyers. And so hindi tayo titigil doon, tuloy-tuloy pa rin tayo. And this year has been again challenging sa sobrang we want you all to make it, especially dito sa subject ko, dito sa subject natin na civil law. Now, I know medyo nalungkot or maybe na panghinaan ng loob, no, because of civil law 1 or 2 and or both, di ba? Pero tandaan nyo, ganun talaga. If you really want something so bad, you have to really work hard for it. Otherwise, it will not be worth it. So, kaya, if you say na nahirapan kayo, pero you're still standing right now, that's already an achievement. So, laban lang. Huwag kayong mawawalan ng pag-asa. This coming Sunday, because I made this before the last exam, this coming Sunday is Redemption Day. Ayan, so bawi, no? Hindi ang civil law exam ang makakapigil sa inyo for reaching your dream. Maybe ito nga or yun nga ang civil law exam ang maging tulay para maging abogado kayo. So anyway, this will be my last video for the bar season 2022. Expect me and more videos in 2023 dahil mas aagahan natin ang ating paggawa ng mga videos para doon naman sa magti-take ng 2023. So doon sa mga nanonood ngayon na nag-exam na this year, we're praying na yan na yung exam na yon na will make you realize your dream. Doon naman sa nanonood ngayon na magte-take ng bar next year, abangan nyo ang ating mga videos because that will be another battle, another laban, and together we will win this battle. So, thank you very much guys for watching my video, and don't forget to like, subscribe, and of course, click that notification bell para maging aware kayo or ma-alert kayo pag may bago akong video. So, that's it from me guys. Thank you very much for your love and support. I'll see you again next time. Laging tatandaan, isip ay buksan, alamin ng batas. Bye guys!